regard to the next factor, that's the competencies associated with youth, including but not limited to the defendant's inability to deal with peace officers or the prosecution, or the defendant's incapacity to assist the defendant's attorney in the defendant's case. I do not find this to be a mitigating factor. You've been zealously represented by experienced and talented attorneys and have been able to present a very thorough defense. Next factor I've considered is the possibility of rehabilitation, and the court finds this mostly to be a mitigating factor. The years that you will spend incarcerated will allow you to learn skills, I guess GED or high set and beyond, depending on how far you want to take it, Mr. Miller. Most importantly, reflect on the immense harm you did to Nohema Graber, her family, and the Fairfield, Iowa community. And then there's a last consideration I've been considered as required by the case law and the statute. With any other information that I've considered in my sentence. In recent years, the Iowa Supreme Court has attempted to find an adequate model approach in juvenile sentencing in compliance with Article 1, Section 17 of the Iowa Constitution, ban on cruel and unusual punishment. It's the 8th Amendment in the federal Constitution. I mentioned the State v. Sweet decision earlier that held that life without the possibility of parole for juveniles is unconstitutionally cruel and unusual, according to that 4-3 Iowa Supreme Court case. In the case your attorney cited earlier, State v. Majors, Justice Waterman wrote, "Our earlier opinions have been criticized for running the risk of making it difficult, if not impossible, for a sentencing judge to ever impose any minimum term of incarceration. Yet, as we indicated in Roby, mandatory minimum sentences are permissible. While there is a presumption against minimum terms of incarceration for juvenile offenders, we have expressly held, even commanded, their use if court concludes that sentence is warranted after consideration of the factors." And those factors are what I just went through, Mr. Miller. And based on recent Iowa precedent, I'm not allowed to consider a sentence of life in prison without the possibility of parole, which is permissible in most other jurisdictions. Certainly a high school junior who formulates a plan, or high schooler that formulates a plan with his friend and murders a Spanish teacher is a dangerous person to the community. The definition of malice is the intention or the desire to do evil. And evil does not have a birthday. This court cannot overrule precedent. However, I will not gloss over the fact that you and Mr. Goodell cut Nohema Graber's precious life short. That would not be justice, regardless of your age, Mr. Miller. The bedrock of our criminal justice system is deterrence and rehabilitation. And ultimately, while acknowledging your youth and developing brain, I find that your intent and actions were sinister and evil. Those acts resulted in the intentional loss of human life in a brutal fashion. There's no excuse. There is not a systemic societal problem that explains or justifies your actions. The court finds, based on the nature and circumstances of this offense, along with the required 25 factors that I am to consider in sentencing a juvenile in the state of Iowa for murder in the first degree, that the defendant, Willard Miller, should be sentenced to life with the possibility of parole after 35 years. This sentence is permissible under the Iowa law. A 35-year mandatory minimum is not cruel and unusual punishment for the defendant, as it represents the appropriate time of incarceration for the defendant in Mr. Goodell's premeditated murder. It is further ordered that the Iowa Medical and Classification Center in Oakdale, Iowa is designated as a reception center to which the defendant is to be delivered by the sheriff of this county. The defendant is given credit for all time served on this charge, including any juvenile detention center. To the extent that doesn't apply to the mandatory minimum, Iowa Code Section 90159, Mr. Miller, does allow your term of incarceration to be reduced because of statutory good conduct time, or credits, program credits, and you may be eligible for your parole after your mandatory has been served. You will have that opportunity to see the parole board and have good time credit at that time. You have the right to appeal your guilty plea, but your attorney must file a written notice of the appeal within 30 days. And we talked about waiving that right at the guilty plea sentencing. If you do want to attempt to challenge your guilty plea, there is an application for permission under Iowa Code Section 81429. The appellate courts determine whether the application is granted or denied or preserved for post-conviction relief. Regarding your sentence, if you're only appealing your sentence, your attorneys must file a notice to the Iowa Supreme Court within 30 days, serve the written notice of the taking of that appeal upon the Jefferson County attorney, and file the same with the clerk of court, together with evidence of that service upon the county attorney, and you must mail or deliver a copy to the Iowa Attorney General's office. The service and the filing of the written notice of appeal and the time and manner just specified is jurisdictional, and a failure to comply with such requirements shall be deemed a voluntary waiver of your right to appeal. You may be entitled to court-appointed counsel to represent you on your appeal and the preparation of these proceedings at state expense. Judgment accordingly, minimus accordingly, and immediately. No bond on appeal. Counsel, for the record, we need to make at this sentencing hearing. From the state.
Just one thing, Judge. I know he will go to the youthful offender unit, I believe, at Oakdale. I don't know if your order needs to specify that specifically or not. I just thought of that a minute ago, so just to put that on your radar. But otherwise, nothing else.
My understanding is they'll automatically send him there when he gets there. Any further record from the defense?
No, Your Honor.
That completes the hearing.